Hello and welcome to Legal Angle. Today we all experience that the prices in Bombay are skyrocketing. And to buy that dream home, we have to invest our hard-earned money. The least we would expect is not get hurt and have the right knowledge. Therefore, to have the right knowledge on various issues, I have with me an expert legal advisor and a good friend of mine, Ankita Verma, who is going to make the process a little smoother for us. Welcome, Ankita.
Thank you.
What are the purchase criteria for a customer when he buys a flat?
When we go to a developer's office, a builder's office to see a new project, the things that we look at are elevation, the size of the house, the amenities that will be provided.
Correct.
But none of us look at whether the land title is clear. And how do we actually ascertain whether the land title is clear?
Right.
So none of us go and ask them what are the revenue documents.
Right.
These are the things which as a prudent purchaser we should go and ask the developer as to the land is in whose name.
Correct.
Second, whether the land has been converted from an agricultural land to a non-agricultural land.
Correct.
Third, revenue documents. When we talk about revenue documents, whether the 712 extract and 612 extract, that are the mutation entries, are in place.
Can you also talk about freehold land and leasehold land from legal perspective to the end consumer?
So, it is very necessary to understand what is a freehold property. First thing. So, a freehold property is completely owned by the person. There is no other third party.
You mean by the developer?
Not just by the developer, it can be the owner as well. Under the Maharashtra Flat Ownership Act, promoters, the term promoter means the owner of the plot as well as the developer.
Oh, okay.
Okay, so a property which is completely conveyed in favor of the owner and or the developer if he is the owner. That is what is known as the freehold property.
Okay.
The leasehold property, on the other hand, is a property where a conveyance hasn't been executed. What is executed there is a lease deed. For example, A is the owner of the property. Probably the government of Maharashtra might be the owner of the property, and they might have leased it out to XYZ party. For example, if we see the Juhu scheme. Juhu scheme is a leasehold property. So it is leased out to various individuals.
It is leased out.
Who then form associations.
Usually, what is the tenure of the year when they lease out?
It can be anything ranging from probably 30 years to 99 years to 999 years.
Okay. Okay.
So 999 years is what we know as perpetual lease.
Okay.
Yes.
Is known as perpetual lease.
Yes.
All right. And it takes me to ask you, does institutions like MCHI and CREDI help the end consumers?
To a certain extent, yes, because they themselves, as we were talking about approvals and sanctions and the title documents, they have the internal committee which reviews the documents, which goes through all these things to make things easier for the end consumer. So if they are proposing a property, if they have it under the banner, probably it has already been checked for the consumer.
Okay.
It is just diligent of the consumer to go through the documents again so that he can be satisfied as to the title of the property. But maximum of the things are already done by the institution.
It is done by the institution already.
Yes.
So who are these members in MCHI and CREDI?
There are a lot of developers which have come together to form the association. The reason behind formation of MCHI was, again, there was the real estate sector was pretty unorganized and was pretty divided. A lot of people didn't know how to. So to facilitate things for the consumers as well as to facilitate things for the developers, institution like MCHI came into existence.
So when buying a home, does a lawyer play an important role for a consumer?
Definitely yes. But maximum of the things, nowadays things are made very easy. It is mandatory for the developer to get a solicitor's certificate as to the title of the property.
Correct.
So maximum of the things are already done by the solicitor of the developer.
Correct. No, I'm not talking about the developer. I'm talking about the consumer.
Exactly. So that title certificate plays a major role for the consumer as well. The reason for it is, after perusing the entire title certificate, he will come to know the exact devolution of title of the property, whether that property is capable of being developed. So all these things will come from a solicitor's title certificate.
Solicitor's title. Well, viewers, we have highlighted on key issues when you purchase and buy a flat. We are going to take a short break and we are going to be back soon. Stay tuned on Spin TV. We'll be back. Welcome back to Legal Angle. We are in chat and discussion with our expert legal advisor, Ankita Verma. Well, these days, builders are opting for project finance. What precautions must a consumer take in a circumstance like this?
So generally what happens is when a builder opts for project finance, an escrow account is created wherein the proceeds come as a purchaser. When you are going ahead and buying such a property, the proceeds that you put in go to the escrow account, from which the project financer can withdraw till the extent the money is due to him. This is how the mechanism of project finance works. However, for a consumer, it won't make much of a difference, provided he gets the property that he is purchasing. He gets an NOC in respect of the property that he is purchasing.
Okay, so it doesn't make a big difference.
It won't make a big difference if a purchaser goes ahead and purchases such a property. However, he must make sure that he goes through the project finance document.
Okay.
Because it might have a mortgage on his flat till the time it is not sold.
Now, who will help our consumer with the project finance documents?
You can directly ask the developer whether he has taken finance in terms of this project. It is also necessary to cause search, because such documents are also registered. Any mortgage deed will have to be registered with the sub-registrar of assurances. So a purchaser can go ahead and call a search in the registrar's office. Okay. He will also come to know from there whether any mortgage document in respect of the property has been created.
So viewers, you all are being very careful here. As we are going under deep discussion, we have also known that project finance document is what you have to ask from the developer. When we get further, it makes me to ask, how is the process of allotment letters in the business of real estate?
Generally, whenever you visit a builder's office, what do? You go, you check the documents. Correct. If we are being prudent enough, you go, you check the documents, you check the plans, you like a flat, you go ahead and say that I want to book it.
Correct.
Right? There and then executing an agreement for sale is not possible.
Correct.
So a builder issues you an allotment letter against what we commonly call as token money.
Okay.
So he issues you an allotment letter with certain terms and conditions.
Correct.
So it is definitely a contract. However, it is not a registered thing. So property doesn't vest into you.
Okay.
However, if you are paying more than 20% of the total consideration value, it is mandatory that you get your agreement for sale registered. The obligation is also upon the developer to get that agreement registered if the consumer has paid more than 20% of the amount. It is
more than 20%?
Yes.
The consumer has to get the agreement
registered. The obligation is also put upon the promoters to get this done.
Okay. So viewers, you all are noting this very carefully. More than 20% you have to get your agreement registered. We also are a little bit skeptical these days about builders. Now, when the project is going on, somewhere over a point of time, it is just stopped because the developer wants to make a little more money. This is what the consumer feels because the money gets rotating and rotating and rotating. How can a legal perspective help the consumer in fighting the battle with developer?
Once you have got your agreement for sale registered,
yes,
you can definitely approach the court for specific performance of such a contract.
Okay.
Also, what these days happens is builders offer that if the construction is not happening, then they might refund the entire money received by them till date with a specific interest amount.
Correct.
So you always have an option whether you want to specifically perform, whether you want the flat itself.
Correct.
Or else you can exit the project if you are not finding it viable, if you are not finding that that the builder is going ahead with the project, you can exit the project with a certain amount of interest on your money paid.
Don't you think the builders in the past, these are media reports, don't you think the builders in the past have returned the money with no interest rate? And how can legal aspect work here in a stronger way to curtail this malpractice?
So what you need to ensure is, while you're checking the documents, while you're signing any document, you must go through it thoroughly. You must insist that all these precautions need to be put in the agreement.
Correct. So the consumer has to be vigilant.
He has to be vigilant, definitely. It shouldn't be a case wherein you sign whatever is presented to you.
Ankita, you know, our viewers are already satisfied with all the answers they are getting, and before purchasing a property, it is a crucial mark from their behalf, and we are helping them in a big manner. You know, we are going to talk a lot about stamp duty registration, but in a short break. Viewers, stay tuned on Spin TV. We'll be back soon. Welcome back here on Spin TV, and we are here with our perfect legal advisor Ankita Verma. Ankita, can you also highlight us the issues of stamp duty registration?
Well, while calculating stamp duty, every purchaser must also know as to how much is the stamp duty payable. So what our law states is it has to be 5% of either the ready reckoner value or the agreement value, whichever is higher.
Okay.
So if you do an agreement which is lesser than a ready reckoner value, the stamp duty is calculated on the ready reckoner value.
Can you throw some light on the ready reckoner value?
The ready reckoner is generally kind of a guideline which comes out every year, which indicates the prices in different areas.
Okay.
So if it is probably 25,000 per square feet in Andheri on the carpet area, it might be somewhere around 11,000, 12,000 in Mulund. So it will give you an indicative rate chart as to which area is having what price.
What price?
Yes. So 5% of the ready reckoner value or your agreement value, whichever is higher, is the stamp duty payable.
Okay.
Along with that, you will have to pay about 30,000, which are the registration charges.
Okay.
So these are the stamp duty and registration charges implications.
So this technically benefits the government.
Yes.
Okay. So this is a duty of the consumer to pay stamp duty and registration. Is it like a fixed amount on the agreement value, or it fluctuates on the rate area wise?
As we said, it is 5%.
Okay.
So if the property in Andheri, suppose the ready reckoner value is 2 crores and your agreement value is 3 crores, then the stamp duty payable will be 5% of 3 crores.
Okay.
However, if the ready reckoner value is 2 crores, however your agreement value is 1 crore, the stamp duty payable will be 5% of 2 crores.
Okay. Now we come on certain issues, you know, on issues like infrastructure cost, parking allotments within the space. Can you throw some light on these factors?
Under the Maharashtra Flat Ownership Act, parking, a developer is not entitled to charge the parking charges or sell parking, basically.
Okay.
So initially when there used to be garages, they used to be sold.
Correct.
Now that is not allowed under the Maharashtra Flat Ownership Act.
Okay.
It is incidental to granting you rights in the flat.
Okay.
So this is where the parking charges are concerned. Of course, hidden costs and everything, the developer is per law not allowed to charge you any of these costs. The cost that you are supposed to pay is on the carpet area,
Okay.
which is shown in the plan.
And parking is a part and parcel of that?
Yes.
So you're not supposed to charge, the developer is not supposed to charge for the parking?
Yes.
So viewers, you have to be very careful when you buy a property. The developers will not charge you for your parking. It is all included in your carpet area price. Now, can you also tell us about the amenities within the areas? Like for example, the maintenance cost that the consumer has to go through, and other factors that complement when the purchaser buys a flat.
Again, there are different heads under which charges are being collected.
Correct.
For example, a few builders charge 12 months maintenance in advance.
Correct.
Electricity meter charges, then share money.
Does it differ from builder to builder, or this is a standard practice in the real estate?
It is a standard practice in the real estate.
So everybody charges the same?
Everybody charges, it depends upon the area again. If
or
you're
it depends on a brand?
No, it depends upon the area. If you're staying in a Sobo flat, okay, the maintenance charges are definitely high there.
Okay.
However, if you're moving towards the suburbs, the maintenance charges go low. So again, it is on per square feet basis.
Correct.
So pro rata basis, whatever is your is the area of your flat, accordingly your maintenance charges will be charged.
Correct.
However, what can be done is that maintenance charge can be specified initially itself. Suppose if the builder is going to charge 15 rupees per square feet, he can specify that in your agreement that I'll be charging at rupees 15 per square feet. This is the calculation and that's why I'm charging so much.
Correct. So it has to be carefully mentioned in the agreement.
Yes.
Now, Ankita, if the builder turns out to be a defaulter, so what steps a consumer can take to fight against a developer?
Defaulter as in what sense? Not completing the project?
Not completing the project. Defaulter is in delaying the project.
The first thing, under civil law, this can be dealt with both in civil law as well as criminal law.
Correct.
Right? So under the civil law, as I said, we have the remedy to specifically to get the agreement specifically performed.
Correct.
But you cannot force the builder that you have to construct the floors. It might sound good legally, but it is not practical. You cannot bombard him that you have to construct these floors. He might just give out any excuse, I am out of funds, or any such excuse can be given. Second option which you have is you can take back the money, get the refund of the money along with a certain interest on it and move out of the property. However, this is also not a very good option because a consumer, when he is putting in probably 1 crore or 2 crores, he is putting in that much amount of money with a view to reside in that particular flat. Right? If you're taking back the amount after probably 2 years, you see the real estate prices have escalated further.
Correct.
So when this escalation takes place, you are not getting the refund on the basis of the escalation that has taken place, but according to the predetermined rate of interest, which doesn't match.
Perfect.
So this is one thing. Second thing, as I said, you have a remedy in criminal law. So if you can find that the builder is deliberately not going ahead with the project, you can definitely file against the developer for cheating.
Okay.
Cheating you because intentionally he duped you into putting that much amount.
Correct.
And after that, he didn't go ahead with the project.
Very good.
So it was completely intentional. However, while going into criminal law, you have to determine the malified intent of the accused party.
Wonderful. So civil law and criminal law. Consumers, viewers, be vigilant that you have to undergo these two laws if the builder is a defaulter. Now, Ankita, before we wrap the show, our viewers would like to know the final golden legal expert words said by you before they invest, because it's a hard-earned money they are putting for a property, and our viewers are anticipating to know where they should not make a mistake and have full knowledge from an expert legal advisor like you.
So as I said, the consumers must be extremely vigilant when investing into any kind of property. They must peruse all the documents as all the documents that we discussed. While taking possession, they must insist on getting an occupation certificate as well. Again, I would request all the consumers not to shy away from taking professional help. It is extremely necessary not to be penny wise, pound foolish. So please take help of legal professionals as well as architectural help, so that you can understand the project better, and the professionals can help you out for smooth sailing through the investing market.
Well, thank you very much, Ankita, for those golden words. And viewers, we here at Spin TV are all geared up to help you with all your grievances, and we make sure that you invest the right way and have the perfect knowledge. Until we meet again, stay tuned on Spin TV. See ya.